President Bola Tinubu and his party, the All Progressives Congress APC, have closed their defense in Peter Obi's suit challenging Mr. Tinubu's victory at the Presidential Election Petition Court in Abuja. Obi of the Labour Party came third in the 25th February presidential election. He is urging the court to overturn Mr. Tinubu's victory on account of electoral fraud and non-compliance with statutory provisions in the conduct of the poll. Tinubu and the APC had on Wednesday opened their defense after Peter Obi finished presenting his case on 23 June. Bola Tinubu, the APC, and Nigeria's Electoral Commission (INEC) are respondents in the suit. They have closed their defense. This sets the stage for its next phase, which involves exchanging final written addresses among parties and a day for closing arguments. At Wednesday's proceedings, Tinubu's lead lawyer, Wole Olanipekun, tendered volumes of documents to defend the president's mandate. Key among the tendered documents were academic records of Mr. Tinubu from the Chicago State University in the US, details of the president's Nigerian passport, and clearance letter from the US Embassy in Nigeria to the Nigeria Police Force. The letter from the US Consulate General in Lagos, dated 4th February 2003, revealed that Mr. Tinubu had no record of criminal conviction of arrest in the US. The 5-member panel of the court, headed by Haruna Tamani, admitted the documents in evidence despite opposition from Obi's lawyer, Levi Uzoku. INEC's lawyer, Abubakar Mahmood, and APC's lead counsel, Lateef Fagbemi, did not object to the admissibility of the documents. After the documents were admitted and marked as exhibits, Olanipekun, a senior advocate of Nigeria, SAN, called Tinubu's first witness. The star witness, Michael Bamidele, a senator, while being led in evidence by Mr. Olanipekun, told the court that Peter Obi was not a genuine member of the Labour Party at the time he vied for Nigeria's presidency. A membership register of the Labour Party in Anambra State, Mr. Obi's home state, Southeast Nigeria, was earlier tendered in evidence to buttress the allegation. Under cross-examination by Lateef Fagbemi SAN, Senator Opeyemi Bamidele, who represent Ekiti Central at the Nigerian Senate, said there can be no criminal conviction of anyone without a charge in the US. Mr. Bamidele, who was called to the New York bar in January 1999, was referring to Mr. Tinubu, whom Obi and Atiku Abubakar of the People's Democratic Party alleged was convicted and forfeited $460,000 in drug-related offenses in the US. However, Mr. Bamidele, the current Senate leader, disagreed with a portion of the ECOWAS Election Observation Mission report concerning widespread violence during the recent general elections. Under cross-examination by Mr. Uzoku and SAN, Mr. Bamidele blamed cases of killings and arson in Nigeria's southeast region on the grisly activities of the indigenous people of Biafra, IPOB. In his testimony on Wednesday, Mr. Bamidele blamed IPOB for the brutal killing of a senatorial ticket holder in Enugu a few days before the presidential and National Assembly elections on 25 February. This was after Mr. Uzoku drew Mr. Bamidele's attention to the ECOWAS report on the outcome of the general elections. Senator Bamidele told the court he agreed with the conclusion, but disagreed with that part of the ECOWAS Election Observation Mission report concerning widespread violence during the polls. After Opeyemi Bamidele concluded his testimony, he was discharged from the witness box. Chief Wole Olanipekun then went on to tender tons of documentary evidence. Subsequently, Olanipekun informed the court that his client's defense had ended. Towing Mr. Olanipekun's line of submission, APC's lawyer, Mr. Fagbemi, adopted the evidence led by Mr. Tinubu's legal team as theirs. Following the conclusion of their defense, the chairman of the 5-member court, Mr. SYMFONI, said the respondents shall have 10 days to file their final written addresses, while the petitioner shall have 7 days to reply. Mr. SYMFONI added that the parties would be notified of when the hearing would resume for the adoption of their final written addresses.